Welcome to the deep dive. We take your source material and, well, we really try to distill the crucial legal principles today. We're jumping into something foundational in contract law consideration. And we've got quite the puzzle for you. Imagine this. A rich uncle promises you, say, 5,000 bucks, a lot of money back then, still is if you give up all your vices. Drinking, smoking, gambling, the works, you do it. You actually follow through. You're healthier, maybe you save some cash, you're just objectively better off, right? But here's the twist, the real legal head scratcher. Can the fact that you benefited so much be used later, maybe by his estate, to say, hey, no contract here, you didn't pay anything? It just seems wild that the law's definition of payment might ignore a huge personal win like that. Okay, let's unpack this.
It is fascinating, isn't it? Because this exact scenario forces us to look past the everyday meaning of consideration or payment. To really get to the bottom of it, we need a clear path. First, we have to nail down the precise legal definition of consideration. Then we'll test that definition against a really key case, a landmark case from New York, Hamer v. Sidway from 1891. And finally, we'll pull it all together into like an actionable checklist for you.
Okay, sounds good. Let's start with the basics then. What's the fundamental legal requirement? The black letter law standard that turns just a promise into something a court will actually enforce?
Right. The core requirement is consideration. Now, the classic definition, it sort of has two sides. It says valuable consideration can be some right, interest, profit, or benefit going to the person making the promise, the promiser, OR. And this is key. It could be some forbearance, detriment, loss, or responsibility that the other party, the promise, takes on, suffers, or gives up.
Okay, so benefit to one side or detriment to the other seems like two options. Which one really carries the weight in court? What's the heart of enforceability here?
It's definitely that second part, the detriment piece. That's really where the legal focus lies. Basically, consideration isn't so much about whether the promiser got something good out of it. It's almost entirely about whether the promise, the one receiving the promise, gave up a legal right they had or, limited their freedom to act in some lawful way, all because of that promise. And legal thinkers really stress this. Courts generally won't dig into whether that thing, that forbearance, was actually worth a lot to anyone in a practical sense. It's enough that a legal freedom was restricted.
Wait, hang on. So the court deliberately ignores, like, the real-world value or the fact it was good for the person. That feels, well, it feels backwards, doesn't it? Is the law really saying a technical loss of a right matters more than, say, getting healthy?
That's precisely the pivot point, yes. It might seem counterintuitive, but the courts are trying very hard not to be judges of morality or personal benefit. They want a clear, objective test. Think about it. If they had to figure out the actual value of quitting drinking for every person, was it worth $100? $10,000? It's just impossible, right? Leads to endless arguments. But did the person have a legal right to drink? Yes. Did they give up that right because of the promise? Yes. That giving up, that objective restriction of freedom, that's the measurable detriment the law cares about.
Okay, I see the logic now. Avoid the subjective mess. Focus on the restriction of rights. So detriment is our key. Let's put this into practice with the case you mentioned. We're looking at a claim for $5,000 against the estate of William E. Story Shimmer. Let's analyze Hamer v. Sidway. First, what are the legally dispositive facts? What actually happened here?
All right. The setup is this. Back in 1869, there's a family gathering, a golden wedding anniversary. William E. Story, Sr., let's call him the uncle, promises his nephew, William E. Story II, who was about 15 at the time, $5,000. But there was a big string attached. The nephew had to completely refrain from drinking alcohol, using tobacco, swearing, and playing cards or billiards for money. He had to stick to this until he turned 21.
Wow, that's quite a list of restrictions for a young man in that era. Did he actually do it?
He did. The record shows he agreed and fully performed all those conditions. He hit 21 on January 31st, 1875. And about a week later, the uncle wrote him a letter. It basically said, yep, you did it. The $5,000 is yours. I've got it in the bank for you. P.S. You can consider this money on interest. The nephew agreed to leave the money with the uncle, earning interest. But then the uncle died in 1887, 12 years later, and he'd never actually paid out the $5,000 principal.
So the nephew turns around and sues the uncle's estate to get the money. We know the promise was made, the nephew performed. So what was the estate's argument? Why did they think they shouldn't have to pay? What was the core legal issue?
The estate's main argument, the central issue, was whether the whole agreement lacked consideration. Specifically, their point was, hey, the nephew actually benefited from not drinking and smoking. He was healthier, maybe saved money. So they argued, since he benefited, He didn't suffer any real detriment, meaning he didn't give anything legally valuable in exchange for the uncle's promise. No detriment, no contract.
Okay, that's the common sense argument laid bare. How did the court deal with that? What rule did the court apply to decide this?
The court went straight to the principle we discussed. It applied the rule that a waiver of any legal right, done at the request of another party, is sufficient consideration for a promise. It's about the detriment, the giving up of a right by the promisee. And that's enough, regardless of whether the promisee personally benefited or if the promiser got any real advantage out of it.
So the rule focuses squarely on waiving a legal right. What was the court's analysis then? How did they reason through it to reject the estate's argument that seemed, well, pretty appealing on the surface?
Well, the court was quite direct. They said accepting the estate's argument that benefiting negates consideration would be a terrible policy. It would force courts into endless speculation in many cases, trying to figure out if the promisee's actions were really beneficial or not. It would put judges in the position of being health experts or moral guardians, which isn't their role in contract law. So the analysis zeroed in purely on the nephew's legal position. Did he have a legal right to drink, smoke, gamble back then? Yes, he absolutely did. He gave up that lawful freedom of action for years, specifically because of his uncle's promise. That restriction, that forbearance from exercising a legal right, is detriment in the eyes of the law. Full stop. So the contract was valid. The court explicitly said it wouldn't even ask if the nephew was better off for it.
Makes sense. Keep it objective, stick to the rights. And the conclusion. What was the final outcome?
The court reversed the lower court's decision that had sided with the estate. They affirmed the original judgment for the plaintiff, the nephew. The promise was enforceable because it was supported by sufficient consideration, defined as the nephew waiving his legal rights.
Okay, this is where it gets really interesting for me. Because that principal detriment means giving up a legal right, not necessarily suffering, seems like it could apply in all sorts of everyday situations, maybe even slightly odd ones. How have other courts run with this idea?
Oh, absolutely. This wasn't just a one-off. Other courts quickly picked up on this exact principle. For instance, there's a Kentucky case, Talbot v. Stemmons. A step-grandmother promised her grandson $500 if he'd stop chewing tobacco and smoking cigars during her lifetime. He did it. The court said, look, maybe quitting tobacco saved him money or made him healthier, sure, but that's irrelevant. The key point, the consideration, was his voluntary surrender of the legal right to use tobacco. That's what made the promise binding.
Right, again, focusing strictly on the loss of freedom, not the outcome. Any other examples like that?
Yep. Take Lakota v. Newton from Massachusetts. A promise to pay $100 if the plaintiff would simply stop drinking for a year. The court shot down the argument that this wasn't valid consideration. Abstinence, giving up the right to drink, was perfectly good consideration. And another one, Lindell v. Rokes in Missouri, same idea. Quitting intoxicating liquors was held to be good consideration for a promissory note. So the pattern is really clear. The law doesn't see giving up these things as just self-improvement. It sees it as giving up something you were legally allowed to do, and that's the price paid for the promise.
I really appreciate how cleanly that cuts through the confusion. It separates the, common sense idea of value from the specific legal requirement. The big takeaway seems to be, if you restrict a lawful freedom because someone promised you something, you've likely provided consideration, and it doesn't matter if you also benefited personally.
Exactly. And if you connect this to the bigger picture, like maybe for an exam or just analyzing any potential contract situation, this principle acts as a sort of firewall. It protects the contract's validity against arguments that nothing valuable was really given up just because the person benefited. So thinking about that, it helps to have a kind of diagnostic checklist, pulling together all these rules we've covered. Here's how you could break it down step by step. First, identify the promise. Whose promise are we actually trying to enforce? In Hamer, it was clearly the uncle's promise of $5,000. Second, define the consideration. What exactly did the person receiving the promise give in return? For the nephew, it was refraining from those specific activities, drinking, smoking, gambling, etc. Third, and this is really the crucial one from Hamer, the Hamer test detriment forbearance. Did the promisee give up a legal right? Did they limit their lawful freedom of action? If yes, bingo, you likely have consideration right there. Fourth, the benefit test, which is secondary now. Did the person making the promise get some direct right, interest, profit, or benefit? Remember, Hamer shows us this isn't strictly necessary if you've already found detriment on the promisee's side. And finally, fifth, the relevance of personal benefit. Just ignore, completely disregard any argument that the consideration was actually good for the promisee. Health benefits, moral improvement, saving money. The court won't get into that. If a legal right was waived, the consideration is generally sufficient.
That's a great framework. So we started with what seemed like a simple family promise about behavior, and we end up drilling down into a really fundamental piece of contract law. Detriment, measured by giving up rights, is the key, not necessarily benefit. It really changes how you look at agreements. So the next time you're thinking about a promise someone made to you, remember Hammer. Ask yourself, what legal freedom, what right did I actually limit or give up to make this promise stick?
Precisely. And just to leave you with something to chew on, remember how the uncle's letter said the money was in the bank and on interest, and the nephew agreed to leave it there? Well, think about this. Did that follow-up exchange just confirm the existing contract debt, or did that specific language in the nephew's agreement maybe shift things? Could it have possibly created a separate trust relationship, where the $5,000 wasn't just a debt owed, but became a specific asset held by the uncle for the nephew earning interest? That potentially changes the whole legal claim. Just something else to mull over.